Mr. Thompson, by the time you wrote that letter to your wife, Kim, you had put together a plan, right?
Yeah, just about, yes.
Right. You were going to try to convince Mark Jensen to get involved in some sort of plot, right?
Sure. Well, not convince him, but, just listen to what he had to say.
Well, it was your idea, from what you've testified to, that you were going to talk to him about getting rid of a witness, right?
I wouldn't say I really initiated that plan. I just went along with what he was talking about and fed into it.
Well, that's what you've been testifying to, is that you're the one who suggested that, right?
Yeah, well.
That's a mischaracterization of the witness's testimony.
It's cross-examination over.
Right?
Let's say we were in together. We planned it together.
Well, you're the one who suggested that.
Okay. If that, yeah.
And Mark had told you that Klug was coming to court, but that he was lying, right?
Yes, he did.
And you also were trying to get Mark to put money on your commissary, true?
I asked him that, yes.
Right, you were trying to get his parents to put money on the commissary.
No, I didn't ask his parents anything.
You were trying to get Mark to get his parents to put money on the commissary.
I asked Mark, would he do it? He said he would talk to his mom.
And that is, you just wanted that for free. You wanted money put on your commissary, right?
Yes.
And you were also initially trying to extort money from Mark, right?
I never extorted anything from Mark. Never tried to. Never.
You were trying to get $500 from him, right?
I wasn't trying to get anything from Mark. That was a part of the plan.
That was your plan to help yourself.
To help myself.
Right. And again, Mark knew from your prior experience of being pushed and shoved that when he didn't go along with what you wanted to do, there could be violence involved.
I don't know. You got to ask Mark that.
And Mark knew that you were insisting on this plan that you came up with, right?
I wasn't insisting on it.
Well, would be fair to say you talked to your lawyer about it, right?
Yes, I did.
And then he said, just keep talking to Mark Jensen, right?
My lawyer said that? I can't recall he said that.
Okay. Do you recall page 4, counsel, when you were being interviewed on October 10th, you said, I mentioned it to my lawyer, Mr. Green, and he said, well, just keep talking to him. And if something comes up, just let me know.
Okay, that could be true.
All right. And then you just kept talking and talking and talking to Mr. Jensen about the plan you had come up with, right?
Well, more or less, I was responding to what Mr. Jensen was talking to me about.
But did you say it, again, page 4, that you just kept talking to him and talking to him?
I didn't try to convince him in anything he was saying, no.
But did you say that to the prosecutors at the last hearing, that you just kept talking to him and talking to him?
Yes, I did kept talking to him. We were conversing with each other.
You were being persistent about your idea for a plan.
No,
right?
I was feeding Mark what he wanted to hear. That's what I was doing.
No money ever changed hands.
No
right?
money ever changed hands.
And you can understand how Mark might say things to appease you, right?
This was for him. It wasn't for me.
Well, your plan that you were talking about was that you were going to keep Mr. Klug in his house until the trial is over.
Yeah.
That was the plan?
Yes.
So you were just going to have somebody wait for Mr. Klug by the garage and then take him in the house and wait for the trial to be over?
That's what I told Mark, but no, I wasn't going to have that done. No, I have no way of having that done.
And Mark Jensen, you're telling me Mark Jensen thought that that was a workable plan?
Evidently, he went along with it. He provided me with the information I needed.
So nobody would think that if a witness in a murder trial doesn't show up for court, that they're not going to go to his house?
Ask your client. He made up the plan.
No, you told me just now that you made up the plan, Mr.
We
Thompson.
made up the plan together. That's what he figured. When it was stipulated, yes, he went along with it. I guess, I don't know if he didn't think anyone would show up or not. Ask him that.
And you kept on asking him and asking him and asking him, right?
No, that's what he told you. Is that what he told you? No, that's not how it happened.
Well, I'm reading from what your interview is. You said I kept talking to him, and finally he would agree. And finally he agreed he would pay to have dude held, or if push came to shove, taken out of the picture.
He agreed to it after our second conversation about it. If that's repeated questioning, then yeah, I guess so. But he agreed to it after the second time we talked about it.
And the plan was to hold him in his own house for a 6-week trial. That was the plan.
That was the plan.
And that would cost $1,000?
No, that was just a roundabout number to use to see what Mark would say.
It would be $1,000 to pay somebody to spend 6 weeks in Appleton, Wisconsin, holding this guy and keeping him away from police that would come to the house looking for a witness.
You must not be listening to my answers.
Just answer the question, sir.
Yeah, that was the plan.
And then you had this phone call that we listened to with Kim, right?
Yes.
And Kim didn't know what was going on in that call, right?
No, she didn't.
You just fed her some information. Here's what to say, right?
Yes.
And by the same token, you just got Mr. Jensen on the phone and said, here's the phone, right?
He knew what was going on, yes.
He didn't have any more idea what was going on than Kim.
Yeah, if you say so.
Now, in those notes, you keep asking for money, right?
No, I only asked for money one time.
All right. You have one note that says, don't forget to tell Mom to leave me the $30.
Right. That was for me. That's what I asked for.
Do you have a note that says, don't forget to tell Mom to leave me the $30?
Yeah, it's on the paperwork that we went over today.
That's right. And then on the same note, you have, I hate to burden you, but do you think Mom could leave me $30 for stamps, soap, toothpaste, and deodorant lotion, right?
That's the same thing.
Well, you're writing it down a couple times, right?
Right, because we have previously, see, those notes were spread out over a week's time.
Over how many?
In the last note, I reminded him that when he was going on his visit Sunday, not to forget to ask her.
Over how many weeks' time?
Just those notes were within weeks, within like 4 or 5 days of each other. You know, they were spread out. They weren't all that took place in one day.
Right, so you were persistently asking him for the $30 and he wasn't doing it.
No, I asked him once and I reminded him not to forget when he was on his visit.
So that's a second request, right?
That's what I said. I asked him twice.
And then you had notes where you kept asking about the $575, right?
Only one note was ever written that I asked about that.
Well, this piece of paper has it written 2 times about $575.
Okay, well, twice then.
Right? And then 2 other notes about when can it be dropped off, right?
Yeah, those notes there took place in the same day. Well, I would say 2 days.
And there was no time when Kim was told to go to the Jensen home and pick up anything, was she?
No, never.
And you're aware from the prosecutor that, in fact, Mr. Jensen had his lawyer go to the judge before this supposed plot ever was disclosed, right?
No, how would I be aware of that?
You didn't hear that from the prosecutor?
I don't recall hearing that.
You indicated that you did look at transcripts?
No, I said he showed me some paperwork, and then he was explaining to me what they were. I didn't see anything, just pieces of paper with writing on them.
Okay. When you say paperwork, he had what's called discovery. You know what discovery is?
I don't know what it was. It was Roy's on paper that he was explaining to me off of. I couldn't tell you exactly what it was. It could have been just regular typing paper with words on it.
He had lots of papers in his cell, right?
Yes.
I mean, stacks of papers, right?
Yes.
And that's also where you would keep his commissary, right?
That's where you keep all your belongings in your cell.
Right. And if you go for a visit, people take your stuff, right?
No, they lock your cell though.
Oh, yeah, so,
I'm sorry, they lock your cell
They
up.
lock your cell.
so nobody's commissary would be stolen during a visit?
Now, if your cell is locked,
Okay. Well, there are two people in a cell, right?
no, Mark had a single cell when I arrived there.
And was his cell always locked?
Whenever he left, whenever you leave a single cell, the cell is always locked.
But in the double cells, people can get at your transcripts, right?
Yeah, in a double cell, yes, your own cellmate could get at your transcripts.
Right. And you were aware that Mark had been in a double cell, right?
Yes, prior to my coming there, I was aware that he was in a double cell.
Right. And the scuttlebutt was that people were looking at Mark's paperwork, right?
People were doing a number of things from what I've heard, yes.
And there was, because this was probably the most interesting case in the jail, right?
I don't know that.
Well, did you hear of a more interesting case than that one?
No, that's the only one that I've heard of, so I couldn't say that it was the most interesting case in the jail. It was the only one that I heard of.
I mean, the inmates were talking about Mark Jensen a lot, right?
I only know, we were only around 10 people. So I wouldn't know what the other inmates were talking about other than the ones on our pod.
And were they talking about Mark Jensen?
No,
No, they didn't talk about Mark Jensen.
no.
You didn't talk to Mr. Bush about Mark Jensen?
Mr. Bush talked to me about Mark Jensen.
And you were completely silent?
I mean, how could I speak of something I had no knowledge of?
And Mr. Clanton talked to you about Mr. Jensen?
Not at all, not to me.
And no other inmate ever talked to you about Mark Jensen?
They just stipulated, that, yeah, that's dude killed his wife, that's it.
And you never talked to anybody else about Mark Jensen?
I know nothing about Mark Jensen.
Have you not been saying that you were talking to Mark Jensen?
This was after me and Mark had our conversations, not prior to any. I knew nothing about Mark. I had never heard of the case, so I came to Kenosha.
Well, after you'd been in there for a few days, you talked to people about Mark, right?
No, I talked to Mark.
Are you telling, and as I'm saying, after that, you haven't talked to other inmates about Mark Jensen?
I've only spoken to 3 inmates on that pod. They were Mr. Bush, Mr. Clanton, and Mr. Jensen.
Well, what about when you're in K-Pod?
No, I didn't talk to anyone about Mr. Jensen and K-Pod.
So Mr. Bush and Mr. Clanton are the only inmates you have ever talked to, Mr. Thompson, about Mr. Jensen in this case.
That's what
Nobody else ever.
No.
Well, who was the person who had the newspaper that was showing it to you and talking about the case?
That was Terry Bush. When I came back from court, they had a newspaper on the unit when I got back from court. And they talked and they told me, you in the newspaper. And I'm like, let me see the paper.
Right, and then you talked about that, right?
No, what was there to talk about? Everyone had read what was in the paper. So what was there to talk about?
So there's no conversation then?
About myself, yeah. I didn't have nothing to say about Mr. Jensen.
And they weren't asking what you had to do with the Jensen
Yeah, they
case?
was asking why I was in the paper. They
So you had some
was more
discussion about it.
concerned about why I was in the paper than what I was in the paper for.
Please let me know the order again that these were in.
I believe that's the order. It could be vice versa the first 2 pages.
Yeah, what's that? That's what I'm about to do. 98, well, let me make sure I get this right. Mr. Thompson. 98, then 96, then 97, then 99, and then 95. Right? Your first note says, when I call Kim, we'll say, all is as it should be. That wasn't a note to Mr. Jensen, was it?
No, not that, no. That's just happened to be on that piece of paper.
That was when that call happened when you and Mr. Jensen were both in J-Pod.
Right.
It has nothing to do with any conversation with Mr. Jensen, right?
I'm just telling you it's on a piece of paper.
Right. They called Kim down to the station asking her if I did any more crimes. They think I've done more banks and some other bullshit.
What about it?
That doesn't have anything to do with any plot, right?
No, that doesn't have anything to do with Mr. Jensen.
And you say, but
No, we were just having idle discussion at that time.
You were what?
We were just having idle discussion amongst each other at that time when I was talking about all that.
Was this on the glass?
Yeah.
And yet the last note here says, let me know after your visit Sunday. I'm going to go call Kim now.
Right.
What Sunday visit was that?
a Sunday visit. You know, he was expecting his mom to come visit him, and he was going to mention the stuff to her that we had talked about as far as getting the money.
And there's never any money offered, right?
There was never any money exchanged, no.
There was never any money, what?
Exchanged.
And even though you were in the reason you moved from J pod to K pod was just because you went to court and you came back and they happened to put you in another pod, right?
Yes, whenever you go to federal court, they give your bed away while you unless you make it back in time to reclaim your bed. They'll put you in different pods.
Right, and so if you went to court on another day, or Mr. Jensen went to court on another day, then one of you then you guys may end up together again, right?
It's a possibility.
And so Mr. Jensen would have known when you're talking through the glass that he may end up back in the same pod with you, right?
Well, no, Mr. Jensen, see, federal court and state court is different. You always go back to the same cell in state court, but the Fed inmates, when they get moved around, there's no telling if you're going to get the same bed or not, because they don't keep your beds.
Right, so Mr. Jensen knew you might be coming back to J at some point, right?
I mean, the possibility was there. Wherever there's an open bunk, that's where they put you.
Or he would be aware that somebody else with you in K may be moved into J, right?
Only if they were a federal inmate.
Well, sometimes people get moved because there's a fight or something like that, right?
Sometimes.
And all these notes in 99, in Exhibit 99, for example, let me just show you that to remind you.
Okay.
All those, you didn't give this to prosecutors until October 10th, right?
I don't know what day it was I gave it to him, but it was somewhere around there.
It was the day you did the video recorded statement, right?
Yes, yes.
And that was over 3 weeks after the first time you talked to him, right?
Could be. I don't know how long a distance it was between the time I talked to him.
And then you had this note when you came back the second time, correct?
Yes.
And certainly this is something you had 3 weeks to work on to produce for them, right?
Well, like I said, those notes didn't take place till after I was moved from J block to K block.
But you had already been moved by the time you talked to them the first time, right?
I don't know if I had or not. I don't know.
And
I knew I was by the time I got those were.
right. And these are things you could just write at any time, right?
Yeah, I could.
You didn't have to write these in response to any. You could just completely make this up, right?
I mean, no. I mean, in actuality, I could have, yes, but I didn't.
Okay. I mean, I could write a note right now that says, "Don't worry about a perjury charge. You'll never be. The prosecution will never bother with that."
Sure.
And I could put it here, and we could act like we were talking like you were worried about a perjury charge.
Sure, you could.
And by the time you produced this to the prosecution, you had had a chance to read the newspaper, right?
I think I had read the paper before, maybe.
So as of September 2007, you were facing, I don't need to turn it, you understand, you were facing over 60 years, or as you said, up to life, right?
I mean, that was what was put on paper, but I knew that I wouldn't be getting that amount of time, though.
And you told your fiance Kim over the phone that you expected credit for turning on the person in Milwaukee and the person and Mark Jensen.
Yes.
That was when you're going to help yourself, right? And you're still expecting credit, right?
I mean, if I get it, I do. If I don't, I don't. It doesn't matter because I know I'm not facing all that time.
You're expecting it, aren't you?
Not necessarily, no, I'm not. Because, I mean, I'm resolved to the fact that whatever happens, happens. So whether I get it or not, I mean, it's not going to hurt one way or the other.
Well, and you're still facing over 20 years in Washington County.
Yeah, I'm not concerned about that either because I'm not going to get that.
Right? And you've been through sentencings before, right?
Yes,
You understand that the judge will consider what kind of man you are, right?
of course.
Right? And he'll consider the fact that you've committed violent crimes, right?
Yes,
He'll consider the fact that you've lied to police and probation agents, right?
yes,
He'll consider the fact that you repeatedly were revoked on parole,
Yes.
right? He'll consider the fact that you committed or were accused of bank robbery, theft of a firearm, possession of a firearm by a felon, marijuana charges, and the theft at the vitamin store, all within 1 year.
he's going to consider whatever I was convicted of.
Oh, are you telling me that a judge won't consider your other misconduct?
Not if it's not a conviction. How can you hold something against me that's not a conviction?
That's what you really think? They can't consider non-conviction like
I
failing?
mean, you probably can consider it. I mean, you can consider he's a murderer, but you won't know till the jury decides, right?
You know, Mr. Thompson, that they can consider what kind of person you've been in the other parts of your life, right?
In some aspect, yeah, but I don't know everything that a judge's job entails.
Yeah. Will you consider what kind of job you had this year?
Me?
Yeah.
Yeah.
And really, all you have going for you is whatever you did to help yourself against Mark Jensen, right?
No. No.
What else do you have going for you, Mr. Thompson?
Because I'm not going to get convicted of all those charges that you so blatantly keep saying.
Now, you told the FBI that you were a felon who possessed that firearm in your home in Washington County,
Yes,
right?
I did, yes.
And you did that because you admit what you do, right?
I did that to protect my wife from going to jail and having our daughter going to social services.
Your wife can't be convicted of having the firearm, Mr. Thompson.
Well, I know that now. I didn't know that at the time I said that, though.
No. What happened is you and Kim have come up with a story since then, right?
If you say so, but no.
I mean, you've been willing to lie in the past to stay out of jail, right?
Yes, I have lied before, yes.
You've been willing to try to use violence to stay out of jail, right?
Yes, I have.
You've used obstructing of witnesses to try to stay out of jail yourself, right?
Obstructing of witnesses?
Yes, like your mother and the stuff, the firearm case.
Never.
Are you telling me your mother was lying when she said you stole it?
That's what I'm telling you. That's why I got found not guilty.
You didn't get found not guilty,
Well,
Mr. Thompson.
it got dismissed. There was no evidence to prove that I actually took that gun. None whatsoever. My mother has Alzheimer's and terminal cancer, and I asked my family to get her to tell the truth, and she didn't know what the truth was, so the judge dismissed it.
So you're saying your mother lied when she said that you admitted to her that you stole the firearm to pay off drug
Yes,
dealers?
because she never saw me do that, nor did anyone see me do that. Yes, she lied.
Basically, your whole past says you'll use any means necessary to limit your exposure to jail and
No,
prison time.
not any means necessary. Any means that I feel that may help me.
Not any means, but any means that you feel will help you, right?
Yeah. I mean, I won't kill anyone to stay out of jail, no.
Any means you feel will help you to avoid 68 years in prison.
I'm not going to get 68 years, no matter how much you try to reiterate that it's not going to happen.
But you could get 30 to life.
I could.
That's all.
Mr. Jambers.
So, Mr. Thompson, when you were in the jail with Mr. Jensen, did you try to get Mr. Jensen to believe that you were an upstanding citizen, a pillar of the community?
No. I mean, no. No one that would be in that kind of jail could ever attempt to achieve something like that.
Did you tell him what you were in for?
Yes.
What'd you tell him you were in for?
I told him I was in for 2 counts of bank robbery.
Did you discuss your other history with him beyond that or not?
No. Not that I can recall, no.
But you did tell him that you knew somebody on the outside that could hold a witness and keep him from testifying?
Yeah, that was fictitious, but I did tell him that, yes.
Or make that witness disappear permanently?
Objection to the leading.
Sustained.
Well, did you say anything about did you say anything to Mr. Jensen about what this friend could do if there was some other option besides just holding the witness?
Probably to some degree, yes.
What did you tell him could be done besides just holding the witness?
Well, actually, he asked me what else could be done. And I told him, I said, well, you know, that would be plan B, you can get rid of them altogether.
And what did Mr. Jensen say in response to that?
He just, like, gave a, sly remark, thumbs up. But he then later said that that's not what he wanted to happen.
Now, I want you to think back to the first time that you ever saw or spoke to Ms. Gabrielle and myself. Mm-hmm. Do you remember that?
Yes.
Where was it that conversation occurred?
I guess somewhere in the Kenosha County Courthouse building.
And at that time, do you know whether or not your attorney was present?
No, he wasn't.
And do you recall whether or not there was any discussion about your attorney and your attorney's presence?
In my attorney's presence?
Do you recall whether or not there was any discussion between you and Ms. Gabrielle and myself about us contacting your attorney?
Yes.
Tell the jury about the conversation, as you can recall, about contacting your attorney.
Well, I wanted to contact my attorney. My attorney wanted you to contact him. And I told you and Ms. Gabrielle that, I would talk to you without my attorney.
But did we want to talk to you without first talking to your lawyer?
No, not at all.
So were there any efforts made to contact your attorney?
Yes, several.
And how much time would you say that occupied during the period of time that we were together?
Pretty much almost half of it.
And while we were trying to contact your attorney, were Ms. Gabrielle and myself asking you questions about this case?
No.
We were simply what?
Objection. No, withdrawn.
What were we doing?
Actually waiting for my lawyer to call back and waiting to get in touch with him, or waiting to see if I would volunteer to talk without him.
And did we ever get a hold of your lawyer?
No.
And at that point, was the conclusion that we're going to have a brief or a lengthy discussion about this case?
Brief.
And why was it going to be brief?
Because we still wanted to try to get in touch with my lawyer, but I just wanted to tell you on my own accord of some of the things that were going on.
And so the first time that we had a more lengthy discussion about this was the next time that we met?
Yes.
And that was on or about October 10th, 2007?
Yes.
And I want to put in context, do you recall my...
Objection to the preface.
Well, it has an argumentative aspect. Go ahead and ask a question.
Okay, well, you were asked questions about what I'd said to you, and I want you to listen to this question and see if that was the rest of what I'd said to you. And this, counsel, is bottom page 1, line 1, or that last line on page 1 is where it begins. But we have done what we said we were going to do, and that is seek to arrange to have you moved to the Ozaukee County Jail.
I object. I can't state the grounds here. Let me see if I can do this in an appropriate way. Well, that's fine. I withdraw.
But we have done what we said we were going to do, and that is seek to arrange to have you moved to the Ozaukee County Jail. Your attorney also asked me that after this case is over and sometime before you reach sentencing in your case, that I'd be willing to write a letter to the judge. I told your attorney that I'd be happy to write a letter to the judge describing your participation in this case, your cooperation with the authorities in this case, and your agreement to testify, and the fact that you testified truthfully.
And I object to anything more as improper bolstering and hearsay.
I disagree, Your Honor, as part of the agreement.
May I see it, please? Overruled.
I told your attorney that I'd be happy to write a letter to the judge describing your participation in this case, your cooperation with the authorities in this case, and your agreement to testify, and the fact that you testified truthfully. And of course, as you know, perhaps without me saying so, is that this whole agreement is predicated upon you being absolutely truthful about anything we ask you. Now, do you remember that agreement?
Yes.
Now, did you have any concerns about the implications or the repercussions of providing information to law enforcement authorities about another inmate in the county jail?
Objection to the relevance.
Did you want to hear?
I just... Sustained.
Now, in this conversation of October 10th, 2007, did you give us any information about what Mark Jensen had said to you beyond the phone conversations? In other words, did you give us any information about what Mark Jensen had said to you about the actual commission of this crime?
At the first meeting or second meeting?
On October 10th, 2007, the second meeting.
I object, Judge, because this is hearsay. It's not prior consistent.
May I see the document again?
Let me find a portion of it I'm going to go to.
The objection is sustained.
Now, Mr. Thompson, during this October 10th discussion with you, did either Ms. Gabrielle or myself explain to you why we hadn't spoken to you since September 18th?
I can't recall, but I don't know. I can't really say.
And I'd object on what I anticipate is going to be hearsay if there's an effort to suggest what Mr. Jamboys or Ms. Gabrielle said.
I wasn't going to try to do that.
Okay.
Well, if it sure sounded that way.
But I'm not going to try to do that.
Oh, are you going to ask a different question then, or?
Yeah.
Oh, okay, excuse me.
Now, I want you to try to remember, to the best of your recollection, exactly how this conversation came around, the conversation between you and Mr. Jensen came around to this issue of making a witness disappear. If you can try to remember back to the first time that came up in any discussion between you and Mr. Jensen, try to tell a jury exactly how this conversation came around to that subject, if you will.
He was talking about I think he first started off with his bail, then he went on to where he was talking about Mr. Klug and some other young lady in St. Louis where they had business luncheon or something together, and he was telling me that they had a business together and that Klug was going to be the one testifying against him because of something that was said down in St. Louis that he had overheard Mark saying, or a statement that Mark had made. And he said Mr. Klug was just being a thorn in his side. And then he wished that it would be, that he couldn't have, that he wouldn't, excuse me, that he wouldn't come to trial testifying against him, because it was supposed to be his friend.
And how did you respond to that?
I told him something to the extent that, well, thorns are made are to get rid of. And he just smiled at me and nodded his head.
I'm going to, and for the council's benefit, it's the last paragraph on page 3. I'm going to ask you, I'm going to direct his attention to the highlighted portion.
I object. This is the same issue. It's hearsay.
Can I see it?
Yes, sir.
Let's just take a couple minutes break. Just about a 2 or 3 minute break. The objection is what, relevance or hearsay?
Both.
What's the portion we're talking about now?
The highlighted portion, Your Honor, and let's remember that there really wasn't a question on the table. I was simply going to ask the witness to read the highlighted portion, and I was just going to ask him if that refreshes his recollection concerning the conversation he had with Mr. Jensen.
And that's not proper. We went through this the other day with Ms. DeFazio. My impeachment of this witness's testimony is the fact he said nothing on September 18th. The fact that he said it some other time later on is not proper rehabilitation. It's a prior. It doesn't satisfy the prior consistent statement hearsay exclusion. And this is hearsay. And it's also improper to have him read things so he can regurgitate them. And he hasn't said his memory is not refreshed. In fact, he's testified at length to similar things. His inconsistency is not because of a lack of recollection. It's because he's lying, which I'm entitled to point out. The DA is not entitled to have him reread things so he can say the exact same thing he said before. They had that chance last night.
Is that it?
In the same room.
Is that, okay. Can I don't want to interrupt opposing counsel, Your Honor. My rationale in terms of having the witness read this statement was that there was extensive cross-examination of this witness about the circumstances surrounding the commencement of this plan to take out a witness. And my recollection, when we first discussed this with Mr. Thompson in any great length, at one point he indicated, he was sort of incredulous, and he'd asked Mr. Jensen, so you really would take this guy out if you got the chance? And Mr. Jensen's reply was, you bet your ass I would. And so what I want is to see if this witness remembers that statement or not.
Oh, gee. I wonder if he'll remember it now.
Well, he's going to get an opportunity to look. I don't know how else to put it. That's the statement I wanted to get out of that. And I don't see how that's improper effort to refresh the witness's recollection about a prior statement that was made when the matters are still fresher in his mind.
They're not fresh in his mind. They're a month later, and the fact that he said it before doesn't allow it to get in. It's hearsay. It's just like a police report.
Well, when you say you want him to read it, you mean read it aloud or just read it?
Read it to himself to see if that refreshes his recollection, Your Honor. That was my purpose. And then the next question, after you've asked a witness to read a document to see if it refreshes the recollection, I'll ask them now that you've had an opportunity to read that, does that refresh your recollection as to the circumstances surrounding the commencement of this conversation between you and Mr. Jensen regarding taking a witness out? And if it did, then I could ask him about it. And if it didn't, then I can't. That's my understanding of how it works.
But he hasn't said that his memory is faulty in this area at all. In fact, he's testified to these things as to his recollection. The district attorney has no entitlement to have a witness regurgitate what they had him previously say. That's how a jury can judge statements, is they can look to prior inconsistencies, because if he's telling the truth, then it should be much more consistent than it is here. And to have him read this and then basically be told, are you able to remember that for at least 30 seconds so you can say it again to the jury? That's not a proper use of prior consistent statements.
Well, I don't know if the witness has indicated exhaustion of his memory. And that would be the precursor, that would be the necessary antecedent to his having his memory refreshed.
Well, Your Honor, I could also get it in then as a prior inconsistent statement, because he has not testified to what's there, and I was asking him about it, and he hasn't testified about it. So I could have put it to him that way, using it as a prior inconsistent statement.
And just the absence of his testifying about it does not make it a prior inconsistent statement. It's the denial of the statement that makes it inconsistent.
But if I were to ask him that, then I would have been leading the witness, and I didn't want to resort to leading the witness.
I'm not going to give you advice on how to ask questions. I'm telling you that the stage has not been set for the usage of this statement. He's not stated his memory is exhausted on the topic. So it's not witness recollection refreshment. He's not said anything inconsistent with it, and it's not. It's obviously not consistent. And if it, because you see, there's been no statement on the subject at all. So
and now, of course, my concern is this: I did make mention of the statement during this discussion, and now the witness has heard it, and I don't want to. I really don't want to have advised the witness in this manner of that statement. So I guess I'll just go on to something else. I won't discuss that anymore with this witness.
As you wish. Ready to go?
Yes.
Yes, Judge.
Ask the jury to come in, please.
Oh, thank you.
No showers.
Defender and U.S. Attorney. Regarding these charges that are against you?
No.
But the result of this plea agreement, the plea agreement was put on the record before you entered your plea in federal district court, right?
Yes.
And under the terms of the plea agreement, what is the date that you're supposed to be released from the federal prison system? Do you know?
I signed a plea agreement for 63 months.
Objection, because the plea agreement would not include such information.
Yeah, the parties can make agreements to recommend certain outcomes to the judge, but ultimately the decision about sentencing is in the hands of the judge alone, within the parameters set by the legislature. So you need to rephrase your question.
Okay. What was your understanding? What was the offer that was put on the table that was accepted by the federal prosecutor? The offer that was put on the table by the federal prosecutors and accepted by your defense attorney on your behalf?
63 to 78 months.
63 to 78 months.
Yes.
So your understanding of the result of this plea agreement is that you're going to get somewhere between 5 years and 3 months in prison and 68 months in prison.
Well, that's if the judge embraces the plea agreement, which the judge is not obliged to do.
Is that your understanding or not?
No, sir. Under 11C1, which is a federal code for that, it's a law that stipulates that under 11C1, it's called a cap, and I can get no more than 78 months, but I can get less than 78 months.
That's your understanding?
Yes.
And now, in terms of these negotiations that occurred between the federal prosecutor and your attorney, were there any discussions, to your knowledge, about your participation in this case?
No, not to my knowledge.
So to your knowledge, the federal prosecutor gave you no credit whatsoever for your participation in this case.
No.
But any benefit that you get, in other words, such as a letter from me or something like that to the judge, you understand that it's contingent
Objection
upon
leading.
one.
Well, I haven't heard the whole question, but it's starting off that way.
I didn't hear the objection, Your Honor.
You said it was a leading question.
Well, I'll try to rephrase it so that it's not. Do you have an understanding as to what the one and only thing is that you're required to do as part of your participation in this case in order to obtain a letter or any benefit whatsoever from the state in this case?
To be truthful.
About any questions that's posed to you?
Yes.
Are you proud of the record that has been laid out before the jury by both the prosecution and the defense in this case?
It is what it is, you know.
No further questions.
Let's see. I don't think I have it.
I'll just move.
Mr. Thompson, while the prosecutor reads your federal plea agreement, who decides what the truth is?
The jury.
Well, who decides in terms of whether you testify truthfully and whether you should get any bargain or not? Who decides that?
Well, I decide whether I testify truthfully or not, but the bargain comes from the judge. I mean, he's not obligated to accept any of this by being in different states.
In order to get a letter saying good things about you and asking you to be treated more leniently, who's the only person that you have to convince of the truth?
The judge, really.
Isn't it Mr. Jamboys?
No, he's just presenting a letter. I mean, it's up to the judge to take into consideration what the letter says.
But if he decides that you didn't testify truthfully, then he doesn't have to follow his bargain, right?
I mean, if he does or doesn't, it doesn't matter.
Well, all of this testimony and your plot and everything was part of a plan to help yourself, right?
Right, but if it doesn't happen, it doesn't happen.
It was time to help yourself, right?
Yes.
And you can only help yourself if Mr. Jamboys is satisfied with what you have to say on that stand, right?
I can help myself by telling the truth. Mr. Jumbo has nothing to do with it. He just made it possible for me to be here.
If Mark Jensen and I decide you're not telling the truth, we can't do anything about it, right?
No one can. Like I said, that's why they have a jury, to determine what the truth is.
So it's your view that you have to convince the jury in order to get your bargain.
Now, the jury will convince themselves by what they determine to be the truth and what's not.
But you recognize the only person who can write a letter that's going to help you out in this case is Mr. Jamboys, true?
Well, actually, you know, when my plea bargain was presented to me, that was the best of help I could have got, was to get 63 to 78 months. Because to get that out of 40 years, I mean, it just doesn't get any better.
And you think that your lawyer in that federal case wouldn't have mentioned to the prosecutors that Mr. Jamboys was going to write this letter and that you'd been cooperating?
I'm sure he would have, but that's not what we're depending on. We were dependent on the fact that when they did the calculations on my federal crimes, that they were calculated to be what they are, 63 to 78 months.
Well, you knew it could be 30 to life, right?
Could be.
Somebody gave you a break, huh?
Yeah.
Do you think they gave you a break based on your clean prior record?
Objection calls for speculation, Your Honor.
No, I got that. Okay.
Let me show you Defendant's Exhibit 102, Mr. Thompson. Let me ask you to read, well, I'll ask you in a moment. Could you look at the front of that and tell me if that's your federal plea agreement? No, I'll help you out.
Yes, that's it.
All right. And it was your claim that the judge couldn't go above 78 months?
No, the judge can go above 78 months if 11C1B isn't implicated.
The judge has complete free reign to go up to the maximum sentence in your case, right?
Yes, he can. He has the ability to give me the whole 40 years, yes.
Right? I mean, could you read paragraph 11 of your plea agreement for me, please?
It is understood by the parties that the sentencing judge is neither a party to nor bound by this plea agreement and may impose a sentence of up to the maximum penalties as set forth above. Defendant further acknowledges that if the court does not accept the sentencing recommendation of the parties, defendant will have no right to withdraw his guilty plea.
So that says the judge can give you 40 years, right?
Yes, he can.
The judge could look at your record and how you've conducted yourself for your entire life and give you something greater than 78 months, right?
That's how they come about the calculations, yes.
And you're still facing 20 years in Washington County,
Yes.
right? And you've lied to the FBI now, right?
Yes,
And you've committed bail jumping by contacting your mother.
yes,
And if a prosecutor wanted to, he could push all those charges, right?
sure, yes.
But you're satisfied in the manner you've been able to help yourself.
I'm just satisfied in the matter that I told the truth. That's the only satisfaction I got from this, is that I'm telling the truth. I've lied about a lot of things in my life that I'm not proud of, but when it comes to the truth, I'm most proud of that.
At least since you lied to the FBI in August.
Yeah, I can lie to the FBI tomorrow. When I lie, I tell the truth, I tell the truth. I have no qualms about what I've lied about.
When you lie, you lie. When you tell the truth, you tell the truth. Is that what you're telling me?
Yeah, I mean, I have lied in order to save myself on occasions. You know, but then also there's been times where, in this instance, where when I was convicted of those 2 bank robberies, like I admitted to a bank robbery that they had no knowledge about. So I mean, I don't see what's the difference in me admitting to accept another 20 years in prison versus not admitting to telling the truth now when it's not costing me nothing.
But it's getting you something.
It's not guaranteed to give me anything.
That's all.
Like I say, I brought charges on myself that didn't even have to be there, all because I wanted to be honest and truthful about them.
That's all I have.
Any question?
No, Your Honor.
You may step down, sir.
Thank you. This is